So this is the 2017 paper, I believe, section A. We're going to be trying these questions. We're going to be discussing them. Obviously, I can't write answers for you, but let's hear what we have to say and how we actually approach these questions, right? So number one, law. Religion and morals exist simultaneously to uphold the rules, right, of proper social behavior that are necessary for the achievement of social cohesion in every well ordered society. Okay. A. Explain three differences between law and morality. Are we able to do that? What would we do? How would we approach this? Okay, what are the three differences between law and morality? So this is where you guys come in. Okay, go ahead.
I guess the sanctions in terms of for morality, you're socially disapproved, and for law, you're punished by the law.
So laws are enforceable, right? Both are enforceable in different ways, right? One is enforceable without any type of governmental intervention, and other is actually like actual serious like legal repercussions, right? So you could speak about the two ways in which they're enforced, right? All right. Any other differences between them? What are the differences between law and morality? Anyone? Okay, go ahead.
Um, Law gets so law derives its authority from the state, whereas morality is like social, cultural, and religious norms.
Lovely. All right. So let's stay to what we're normally talking about, right? When you are looking at the differences between the states, not between the states, between law and morality and law and religion, right? There are three different things that I tend to look at, right? So I don't know if you want to write them down or whatever, right? It's always the source, the nature, and the enforcement. It's always those, right? So where does law come from? The state. Where does morality come from? Religious beliefs or social norms. Lovely, right? The nature of law, right? It's formal. It's dealing with clear rules and regulations, and it has a specific framework for acceptable and unacceptable behavior. While morality is more subjective and informal, encompassing a broad range of human behavior. Right? That's how they're different in nature. For enforcement, law is enforced by official institutions, the courts, the police, other different regulatory bodies. Morality is enforced through social pressure, guilt, and personal conscience. So usually when I'm asked to differentiate between law and morality or law and religion or anything like that, I always use source, nature, and enforcement. Those three things. You can always differentiate them on those three things. Right? If you're asked to differentiate on others, you could speak about the objective of law. Right? What is law there to do? What is morality there to do? Right? So use key headings and differentiate them under those key headings. It makes it much easier. All right. Any issues there? All right. Lovely. Okay, somebody has there. Okay, so I'm reading the chat. No. So define law and morality. Okay, so somebody said that you define law and morality first. I think that's important. Define law and morality before you look at the differences. Right, Cesaria says the source, right? We have the source, the nature and objectives, the enforcement, okay. Source, sanctions, alright. We have that there. So general enforcement is that. We're talking about enforcement and stuff like that. Okay, lovely. Right, so we all are on the same track, right? No, Mr. Consile, I think, advertises on his Facebook page for workers to provide escort services for customers of his nightclub. 2 weeks later, he is arrested and charged for the offense of conspiracy to corrupt public morals. Mr. Consell is convicted and sent to prison for 15 years. With reference to two decided cases, discuss three ways in which each of the following may have influenced the outcome of the case. What are the two decided cases that we're going to be using? What are the two? State them, state their year as well. Shaw v. DPP 1962
R versus Noller,
and RV
19,
1972.
1972.
RV Nola. Alright? So we have those things. You think RV Nola will be more applicable? Yeah, RV Nola Limited is more applicable, right? So we have Shaw v. DPP and RV Nola. Lovely. Right? Three ways in which the following could influence the outcome. How can religion influence the outcome of the case? You could speak about the religious morals and principles, right, that speak to prostitution and stuff like that. You could speak to the moral implications. Use the cases wisely. What was the moral implication in Shaw v. DPP that resulted in the conviction? What was the religious implications in RV Nola that resulted in the conviction? Right? These things you guys have to discuss. Are the years necessary? Well, are you saying that, okay, without the years that you will lose a bunch of marks? No. But it's just practice. It's just proper practice, you know? So the years can be, if you don't remember the years, just write the case. Alright? But we're looking at that, right? So looking at these two cases, we're going to be using these cases. I think I would use RV Nola more so and speak about the religious consequences, right? And I will use Shaw v. DPP to speak about the moral consequences. Those are two decided cases I would use. Even though both is moral, RV Nola is more religiously embedded than Shaw v. DPP. So speak about those two things. You guys should be fine. The question should be easy marks, right? And remember your IRAC rules, right? Remember your IRAC. Do you guys remember IRAC?
Yes, sir.
What is IRAC?
Issue, reason, application, conclusion.
Okay.
I know, sir, what I know is issue, rule, application, and conclusion. I didn't know that the R was reason.
Okay, I use rule or reason, right? But what I tend to use ratio decidendi, right? So the issue, the rule or reason, your application or analysis, right? And then you have your conclusion. You see, when I went into that paper too, that is the only thing I used. Only thing. I don't do anything other than that. All I do is issue, write the issue. Rule, write the rule. That's all you need to do. They never ask for write an essay. Right? Just do what you're doing. And it makes it much easier to see clearly what you're doing when you use bulletins and write the issue, the rule, the analysis, and the conclusion. Right? And the conclusion is usually the verdict. In your conclusion, I'm not saying that you have to do it, but it's a difference between a one and a complete distinction. You should know generally sentencing theory once you complete module 3, right? If you can speak to the type of sentence that may occur, you can use it in conclusion, right? Because I mentioned every sentence. Because I know the sentencing for murder, for manslaughter, for rape, for all of them, right? So I put it in the conclusions, right? So those type of things, the more you know and the specificity that you have is what you're going to be using to get that one in law, right? And that means that you actually have to know what you're talking about. Because if you don't know what you're talking about, you can't be specific, right? So speaking about those things, so use up the rules, right? Here now, over the years, Caribbean judges have consistently utilized the rules of statutory interpretation in determining the meanings of statutes. A. 1. Outline 2 advantages of utilizing the literal rule for statutory interpretation. What are 2 advantages of using the literal rule? Advantages of using statutory interpretation. Let's go.
Is it that the meaning of the word will be just clear and original?
I think that's describing the literal rule more so than speaking about the advantages. So not necessarily. Advantages of using the literal rule. It upholds parliamentary supremacy or sovereignty, right? It upholds parliamentary supremacy, right? It allows for clarity and predictability, and it is efficient. Those are 3 different advantages. It is efficient because they don't have to think about, oh, what is Parliament trying to say? Let's figure out this and construe the meaning. If the literal rule can be applied, it is extremely efficient. Just look at the literal meaning of the words, case done. Very efficient, right? So you could look at that. So the literal rule makes the process really more straightforward and efficient in that case. We could speak about the fact that it upholds parliamentary sovereignty, in which what we're looking at is that the law is truly handed down from Parliament, and all the judges do is read exactly from the law, right? So the judges have no part in creating new law, because statutory interpretation can allow for the creation of new law. We have the predictability and clarity that we can get from the literal rule. It ensures a clear and predictable legal system, right? Individuals and entitles, right, can understand and rely on, right, the straightforward language of statute, right? We're looking at these things. 4 marks, that should be fine. 4 and 4 alone. With reference to one decided case, explain the mischief rule of statutory interpretation. Can anybody give me a decided case? Okay, did Tony ask, can I repeat what? What am I supposed to repeat? Oh, you look at the advantages. Oh, sorry. Probably was speaking a bit fast. Okay, what is the case that would use for mischief rule? I gave you the case.
Hide and hide.
Hide and hide. What happened?
Oh, sorry. No. R versus George Green.
Arch versus George Green. Fraser versus Greenway, right? Magor and St. Melons versus Newport Corporation. Those type of things. Baptiste versus Alain is actually going to be on the literal rule, right? Not on the mischief rule. So you need to remember the case on the mischief rule, right? So R versus George Green or Fraser versus Greenway. What is the mischief rule though? Could somebody explain the mischief rule for me, please? Explain it. What is it about? What does it seek to do?
It gives judges 3 main factors in terms of, in order for the mischief rule to be applicable, there are 3 main factors in which judges decide the cases. So, and these will be what the law was before the statute was passed, what the mischief the statute is trying to remedy, and what remedy Parliament is trying to provide.
Okay, so we're looking at those things that were passed on from the Hayden's case of 1584? 1584, somewhere there around there, right? So looking at those things, right? And the mischief rule really arise when there is ambiguity or a lack of understanding or an error within the statute. So the judges have to look at the statute now and realize that, okay, this is causing some type of of issue, right? What was the original problem that the legislation was trying to fix? What is the original mischief, right, that the statute is trying to remedy, right? And then we look at an interpretation of the law that will fix the issue, right? So all you have to do is explain the mischief rule, and how you can aid your explanation is using your cases. RV Greenway, um, well, sorry, Fraser v. Greenway, right, which is 1991, and RV George Green, which is 1969, right? Those things. Lovely. B. Brad's murderers, right? Sorry, Brad murders his mother. Is this? Yeah. So Brad murders his mother, Jane, who has not made a will. Jane leaves a is murders that say? That's crazy. So Brad murders his mother, Jane, who has not made a will. Jane leaves a house and money in the bank, right? Her two sons, Brad and Peter, are her next of kin. Section 7 of the Administration of Justice Act provides that the next of kin shall inherit the deceased property. 1. State the rule of statutory interpretation that would apply in this case. What are the rules that can apply? What is the rule that we're using in this case? Brad killing mother, and the act say all his mother's holdings must go to him. What interpretation would be used? It's a very beautiful rule. It's a very lucrative rule. It's very shiny on the eyes, you know? The golden rule. Lovely. So we're going to be using the golden rule. Can anybody tell me why? What is the golden rule for? What's the function of the golden rule? Go ahead.
Is to prevent an interpretation that would lead to an absurd consequence.
Lovely. In this case, the mother's murderer, right, getting all of her holdings is an absurd consequence, right? So the golden rule must be used. 2. Advise Peter on whether or not he can succeed in a court action challenging Brad's right to a share, right, in their mother's property. Use 2 decided cases to support your argument. Mm. Mm-mm-mm. Golden rule. Chief Justice Park B. Jerry's would have laid out, right, the principles of the golden rule in Mattison v. Hart. So if you could write up Mattison v. Hart, 1854, and in Gray v. Pearson, 1857, I believe, right? I think specifically in Gray v. Pearson, 1857, he laid out what the golden rule is for. So that's a locus classicus. That's where we get the golden rule for. Gray v. Pearson, 1857. And now one of the more recent cases is Davis v. R, 1962. And we're going to be using these cases to advise Peter on whether or not he can succeed. You guys got the cases? I think Mattison v. Hart, which is I think 1854, Gray v. Pearson 1857, and Davis v. R 1962.
Excuse me, sir. Can you spell Madison?
Mattison, Mattison.
I can't see.
So Mattison v. Hart, right? And I can just type them in the chat, I guess. Gray v. Pearson. And this is, I think, what would be called the locus classicus in this case. Right? And we can have Davis What was it? R. Davis versus Regina. Right. 1962. All right. Lovely. So those cases can be used there. All right. Shouldn't be a problem. And then all you use it to advise. All right. So you see those questions where they ask to advise a person, right? What I tend to do, right? I don't tell the person whether or not I don't tell the person if that they can win, and I don't tell the person that they're gonna lose, I argue both sides of the argument always. I never say one thing, I never say anything like that, I always argue both sides of the same thing. Right? Always argue both sides. So I'm gonna tell you what are the chances that you can win, what are the chances that you can lose. I always talk about that. And for that you need to understand, right? Case law, you need to understand your stare decisis, you need to know your precedents, right? And use your cases in your answer. Alright? So that is for that. So I think that's the end of the 2017 module 1, right, section there.